Matter Joyce Miller versus.
For the record, this matter is before the court for purpose of entering a proposed consent judgment of divorce. This hearing is being conducted via Zoom. Present is Attorney Christina Hills representing the plaintiff Joyce Miller. And Joyce Miller appears to be present, as is the defendant Michael Miller. Good morning, everyone.
Good morning, Your Honor.
Morning.
Good morning.
Mr. Miller, before we begin, I just want to make sure you understand that even though Ms. Hills is helping facilitate resolution of this matter, she's prepared the judgment of divorce, incorporated your agreement. She, however, represents your wife, Joyce, and her loyalties lie with Joyce. Do you understand that, sir?
Yes, sir.
But nevertheless, you've approved this judgment of divorce freely and voluntarily. Is that correct?
Yes.
All right, Mr. and Ms. Miller, can you both please raise your right hand to be sworn, please? Your right hand, ma'am?
Sorry.
Thank you. Do you
You
both
are the
solemnly
plaintiff
swear?
in this matter, correct?
Yes.
At the time you filed your complaint for divorce, had you been a resident of Michigan for at least 180 days
Yes.
and of Monroe County for at least 10 days?
Yes.
Is it true that there's been a breakdown of your marriage relationship to the extent that the objects of matrimony have been destroyed and there's no reasonable likelihood that your marriage can be preserved?
Yes.
Are you pregnant?
No.
You and Mr. Miller have any minor children who were born to or adopted by the two of you?
No.
Are you asking for the opportunity to have your former name of Waite, W-A-I-T-E, restored to you?
Yes. And then when I went to.
Okay. You've signed off on a proposed judgment of divorce, correct?
Yes.
Before you signed that proposed judgment of divorce, did you read it?
Yes.
Did you understand all of its terms?
Yes.
Did you have enough time to think through all of those issues?
Yes.
Do you have any questions about it as you sit there right now?
No.
You understand that spousal support, also called alimony, is barred as to both you and Mr. Miller?
Yes.
That means neither one of you would be able to come into court in the future and ask for it. Do you understand that?
I understand.
You understand you could have had a trial in this case? We could have presented all of the evidence in your case to the court, let the judge make all of the decisions?
Yes, I understand.
If we'd done that, you might have done better, you might have done worse, or the judge could have ordered something very similar to what you've agreed to. Do you understand that?
Yes.
Are you asking the court to sign off on that proposed judgment of divorce and grant you a divorce today?
Yes.
Are you satisfied with my services on your behalf?
Yes.
Thank you. I have no further questions.
Thank you, Ms. Hills. Mr. Miller, could you please state your name and current mailing address for the record, please?
Michael Lewis.
Mr. Miller, did you hear the testimony of your wife, Joyce, this morning?
Yes.
Was her testimony true and accurate to the best of your knowledge?
Yes.
Do you have any questions for the court?
No.
Do you have any questions for Attorney Christina Hills?
No.
Ms. Hills, do you have any questions of Mr. Miller?
No, Your Honor. Thank you.
The court would like to thank and acknowledge Ms. Hills for helping facilitate ample resolution of this matter, and the court would applaud the two of you, Mr. and Mr. Miller, for reaching your own agreement. Without question, the best resolution of matters of this nature is one which you both participate and ultimately agree upon. Far better off than have the court make these decisions. Based, however, on the testimony that's been presented this morning, as well as claim filed in this case, court finds that jurisdiction has been established. The court further finds that there has been a breakdown of the marriage relationship to the extent that the objects of matrimony have been destroyed, and there appears to be no reasonable likelihood that the marriage can be preserved. Accordingly, it is ordered by this court that the marriage between the parties be and is hereby dissolved, and judgment shall enter granting a divorce from the bonds of matrimony. The court has signed the judgment. Good luck to both of you. That will conclude this hearing. You can all zoom out. Have the rest of the day.
Thank you, Your Honor. You too.
Welcome.
Thank you.
Welcome.
Thank you.
Guys.
Good morning, Ms. Patrick.
Good morning, Your Honor. How are you?
Did you ever hear back from Andrea?
No, I have not. I spoke to Mr. McBee on Friday, but I have not heard anything since then.
Okay, because there were.
I can reach out to him again today.
He was going to talk with Andrea. I think she's back today, or maybe it's tomorrow she's back, and to see whether, just curious whether or not she's going to, staff will make a recommendation, or do they still need a supplemental letter from us? I'd rather them just make a recommendation.
Yes. I will touch
Okay.
base with him this afternoon and get an answer for you.
If you were called to.
Do you want the 9:30, Sarah?
Once again, this matter is before the court for the purpose of reviewing custody and parenting time. This hearing is being conducted via Zoom. President Attorney Tressa Wilkes representing herself this morning, and Attorney Alexis Stang is present representing the plaintiff, Father Jake Hurley. Mr. Hurley is with Ms. Stang. The parties have conferred with Mr. Walker from the front of the court this morning, who has provided the court the following recommendation. Is that mother's parenting time should be modified. Shall have parenting time every Monday from 4 p.m. to 7 p.m. and every other Saturday and Sunday from 10 a.m. to 6 p.m. No overnights at this time. Weekend parenting time for mothers shall commence August 17th and 18th. which is weekend following the coming weekend. Further, the party shall appear back before this court to review custody parenting time on October 1st at 10 a.m. That is recommendation. Ms. Stang, is this recommendation good with your client this morning?
Yes, it is. Thank you, Your Honor.
Well, do you understand the recommendation?
Yes.
Do you have any objection to the court adopting this recommendation as an order?
No.
Do you have any questions?
No, I don't.
Okay, and Ms. Stang, Mr. Early's been providing all the transportation, is that correct?
No. Teresa has been transporting, I believe.
Okay, is that, I just want to make sure it was on the same page. So any prior orders will continue in full force and effect unless they've been changed by this order, Ms. Wilkes, you understand that?
Yes.
Hopefully we can move back to overnights when we come back for the review in October. And where's Aiden going to attend school this fall, Ms. Stang?
Manor Elementary.
At Manor Elementary.
Manor Elementary? Okay,
Yes.
so he's all set and enrolled and so forth?
Yes.
Okay. And it's important, Ms. Wilkes, you be involved in his education, make sure that you are signed up as with the school. So you're aware of all activities, parent-teacher conferences and so forth. Right. Anything further this morning, Ms. Stang?
No, thank you, Your Honor. That was all.
Right, the court just would note for the record, when we're last in court on May 28th, 2024, the court did refer the issue of custody and parenting time to the front of the court for a formal investigation recommendation. The court has received the report and recommendation from Catherine Scott at the front of the court dated August 5, 2024, which recommends joint legal physical with the father, mother's parenting time alternate weekends, and those we can further review that when we come back for this review in October. Right, with that, the court will adopt the recommendation of Mr. Walker. Thank you, Mr. Walker, and that will conclude this hearing. Everyone can zoom out, and we will see you in October, Ms. Wilkes. October 1st, 10 a.m. You'll receive a copy of this order. It'll be a Zoom hearing once again, okay?
Thank you.
You're welcome. Thank you both. Father's motion for immediate return of the minor child, as well as plaintiff father's motion to modify custody and parenting time. This hearing is being conducted via Zoom. Present is Attorney Hassad Hamad, representing the plaintiff father, Edward Kind. Mr. Kind appears to be present with Mr. Hamad. In addition, defendant mother, Shimane Johnson, appears to be present. Is the child been returned to father, Mr. Hamad?
No, Your Honor.
All right, Ms. Johnson,
Yes, Your Honor.
where's the child at?
She is with my daughter while I'm doing this court hearing.
Well, until such time as there's an order entered by the court, if there's it's week on, week off parenting time. You just can't unilaterally change parenting time. If you feel the child's in danger, you call protective services, call law enforcement. But absent that, the child needs to be returned to father.
I'm working with Child Protective Services as well as Hope Shores Alliances, their domestic violence coordination. And there's a lot of abuse going on in the home. I was living in the home with the father as well as the child, and the father has been abusive in front of the child towards me, as well as allowing sex offenders around the child still that are in the court order, previous court orders, to not be around the
I'm going to
child.
object to this testimony as it's not founded and
Right, Ms. Johnson, Mr. Walker, for the further court, did your office receive any reports from protective services? Mr.
Oh, Your Honor, the front of the court has not received any recent
Right.
reports.
Mr. Ahmad, has your client been contacted by protective services in the last 30 days?
no, Your Honor. Their protective services are not involved in this case. This is a repeat of 2022 and 2023, the same type of allegations that Ms. Johnson does all the time. She contacted the FBI last time and said he was a sex trafficker. This is always the same rhetoric. And back in February, this court heard that Ms. Johnson had overdosed, and that's where there was drug testing that was supposed to be done by Ms. Johnson, that the parties got back together to try to keep the family together and raise this child from February of this year until July. And in July, when they had an argument, Ms. Johnson decided to just walk away again, take the child, and he hasn't seen the child for 30 days. And that's not acceptable. Not every time Ms. Johnson decides she wants to alienate this father from his daughter, she chooses to do so. He's 71 years old, guy works every day, hardworking man, has never done any drugs in his life, and he wanted to keep Ms. Johnson under his purview and his care to make sure that if she was using, at least he would have control of that when Essence was with him, this minor, and she's not in a dangerous situation. Now we don't know where this child is. We don't know what he believes, that there was a guy she met online that she actually went up north and she stayed with for two weeks with this minor child. Have no idea who this guy is. There might be drug use. We don't know if she currently is positive for any type of drug use. Last time she was using crack cocaine in under his house when he reported it. So there's a big concern here. And again, she's using this sex trafficking again. Now it's domestic violence, but she never called the police. They never came out and said and arrested my client for domestic violence. This is all new stuff that now she's going to bring up to this court, and it's unacceptable. She can't continue to use this court to effectuate her fraud upon this court and keep continuing with these lies. It's just unacceptable.
Well, she's not using this court to do that. She's just on her own volition, is ignoring court orders, Mr. Ahmad. Ms. Johnson, the child needs to be returned to Mr. Kind today. Is there any reason why the child can't be
Your
returned
Honor.
today? Ms.
All
Johnson,
of these,
you must file court orders. I know you got a motion to change custody, and that's set for before the referee tomorrow. Mr. Ahmad, are you aware there's a referee hearing tomorrow?
Your
1
Honor,
o'clock?
I would like that to be adjourned. The
It's
reason
not before this court, it's for the referee.
but I figured, oh, that's fine.
Mr. Kind,
If I
Mr.
may-
Kind can appear tomorrow at the referee hearing. Mr. Johnson, where's the child at right now? Is the child here in Monroe
She's
County?
she's in Westland, Michigan.
Okay, well, you ordered to bring that child down to Monroe, the return child to Mr. Kind at noon today. Right now it's 10:15, so you got a couple of hours. So where are you gonna bring the child back to Monroe? Where are you gonna meet?
Your Honor, I would like to have this session adjourned until I can
Ms.
get
Johnson,
some
we'll
type
give you a
of
date to
legal.
review this, but in the meantime, the child's gonna be with dad. So what do you need, 2 weeks?
The
to get
child is
attorney?
not safe with her father, and he also has a no occupancy permit listing on his home. The house is not safe there. I need legal help.
Your Honor,
Ms.
again,
Johnson, you just lived in that home, did you not?
Yeah, and that's why we left put the order on there. City of Taylor has put the order on there on 7/19.
Okay, Mr.
July
Ahmad, are you aware,
19th.
is there some, is the municipality vacating or?
no, the
Kind?
city's coming out for an inspection. The house is in fine care. There needs to be a renewal of a certificate of occupancy. It's not a condemned home. Actually, it's in very great shape, more than people live normally. And she lived there for a long time, and she knows that there's no problems with this home. So
There
this
is
is
there
just,
a bed?
this is
Is there
another
a bed and bedroom
point.
for the child?
Yes, absolutely. There's
Right.
bedrooms.
Ms.
Inside
Johnson?
a garage.
CPS
The
Ms.
the
Johnson.
bedroom is inside
Ms.
a garage.
Johnson.
The child.
Ms. Johnson, your order to return the child at noon today to Mr. Kind. Do you understand that? The only question is where are we
Yes.
gonna meet?
Your Honor, because he is currently here in Dearborn, Michigan, she doesn't need to drive to Monroe. If the child's in Westland, they can meet at the Dearborn Heights Police Station, and they can exchange the child at the Dearborn Heights Police Station inside, so this way there's no issues.
And Ms. Johnson, will that work?
I would like to state something for the
And
record,
we'll give you a date for
please.
review. We can come back in a couple weeks. You can come back with an attorney. But Ms. Johnson, can you meet at the
A
Dearborn
false ex
Heights
parte order
Police
to
Department
get
today?
custody is criminal.
Ms. Johnson, is it okay
Yes.
to meet at the Dearborn Heights Police Department today?
I would like to say one thing for the record. A false ex parte order to get custody is criminal, and criminal complaints on the judge who violates the law can also be in place.
Okay, your comments so noted on the record, Ms. Johnson. And where do you want to
Thank you.
meet today at noon? Is that okay to meet? It probably makes the most sense to meet at a police station. Ms. Johnson?
I guess wherever Mr. Kind would like to meet, since it's not
Okay.
in the best interest of my child, it's in the best interest of Mr. Kind and what allegations he has made to the courts. I would like to do a drug test to prove that I'm not on drugs. I would like you to please order hair tests so I can prove that there's been no drugs. I would like you to send somebody out to his home to see that it is in the perfect condition that they say that it is in. Your Honor, I have been there. I've been through it. Mr. Kind is an abusive man. He has abused me in front of my child.
Right, that's why we're not gonna be contact. We're not gonna be contact. You meet at the police department. Meet at the police department. So we're gonna put this over for a couple of weeks. You come back with an attorney and you're offering to
Just
take a
one
drug
more
test,
thing,
Ms.
Your Honor,
Johnson, is
and I'm
that
sorry
correct?
to interrupt.
Ms. Johnson, are you offering to take a
And
drug test?
how are we to know that he's going to stop putting sex offenders in the home with my child?
Mr. Ahmad, with whom does Mr. Kind reside?
Nobody. This is the same
Okay.
stuff she said in 23 and 22, and it's not acceptable.
Nope, that's not true.
Okay, Ms.
That's
Johnson.
not true.
Ms. Johnson, are you offering to take a drug test?
Yes, I am, Your Honor.
All right, court will order, we're gonna put this over for a couple of weeks. The court's gonna order that Ms. Johnson return the child to Mr. Kind today at 12 noon at the Dearborn Heights Police Department. You know where that's located, Ms. Johnson?
Yes, I do, Your Honor.
Okay, so you meet there and the child will remain with Mr. Mr. Kind till we come back. The child has been, the father's been denied the child since July 15th. Is that correct, Mr. Ahmad?
July 9th, that's
There's an
correct.
active
July
CPS
15th.
case that
So we're
is
gonna-
July 15th.
prohibiting
Right.
me from returning the child to the father.
That's not true. That's completely false.
Yes,
Right,
it
Ms.
is.
Johnson,
I
Ms.
have
Johnson,
the
the court's made a
paperwork
decision.
with
We're gonna set this in order. We're gonna put a review date in a couple weeks. Do you need 2 weeks in which to get the drug test done? The hair follicle drug test?
No, I can do it right now today.
Okay, good. But you need some time. Do you want to talk with an attorney, correct?
I do need to talk with an attorney, but I do not think that it is in the best interest of the child to be returned to her father while there's a sex offender that is on the property and there's numerous drug activities and criminal activities that are going on his property. Mr. Hamadi could say that it's untrue all he wants, but he's not there. He did not live there with the child. The child is in danger with her father.
So, Mr. Ahmad, any objection to the court ordering that no other parties can reside in that home till we come back?
Yeah. Does anybody reside in? No. Yeah, that's fine, Your Honor.
All right, so the court will address that, Ms. Johnson. Again, the order is that you return the child to Mr. Kind today at 12 noon at the Dearborn Heights Police Department. Mr. Kind will have possession of the child until we come back to court in a couple weeks, which will give you a date in a mile. Ms. Johnson, you are to submit to a hair follicle test and provide the results to the court and to Mr. Ahmad when we come back, before we come back. And finally, the court will order that Mr. Kind not allow any other person to reside in the home till we come back, determine who's
That's
else
fine.
living in the home.
So once again,
And we
you're
have
going to
review
place
dates.
a child, a
August
3-year-old child
21st
with
at
a
9
sex
a.m.
offender.
Just a minute, Ms.
Once again,
Kind,
Your
Ms.
Honor,
Johnson. Mr. Ahmad, are you
You're placing
available?
a child, a 3-year-old little girl with a sex offender family of known
August
sexual
21st, 9:45, are you
abuse
available,
to
Mr. Ahmad?
children in the family.
Yes, Your Honor. Is that in person or on Zoom?
Besides Zoom.
Okay,
Ms.
that works.
Johnson,
That's fine.
So, Ms. Johnson, make
So
sure the
you're
front court
putting
has
a
your valid
child with a
address
sex
so we
offender
can mail
once
you a
again,
copy of
Your
this
Honor.
order. All your objections are noted, Ms. Johnson. Make sure the front of the court, when you're in the courthouse today, go down to the front of the court, make sure they have Mr. Walker as your correct mailing address, so a copy of this order is mailed to you. Got it?
You
You want
have
to be
my
here
correct
August
mailing address.
21st
I've
at
received
9:45
them.
a.m.
Your Honor, I
Yeah.
also want to address if she's requesting an attorney and this court knows that there's a referee hearing tomorrow, it doesn't make sense that there's a hearing tomorrow when she's requesting an attorney.
It doesn't
Well,
make, no,
she
I would
filed
like
the
to go in
motion
front
pro
of
per, Mr.
Jennifer
Ahmad.
Comrich.
So
All right.
the
Is that it?
referee may, in fact, put it over to, do you want to put everything over? Ms. Johnson, do you want to put your motion over before this court on August 21st at 9:45?
I would like to carry on with tomorrow being the day. I'm ready to go forward with this.
All right, all right.
And,
The referee, most likely,
referee seems-
Mr. Ahmad, will adjourn the matter to this court's docket August 21st, but we'll see. She wants to keep it on, and that's her motion in pro per, so maybe Mr. Kind can appear. And,
Okay, are those-
if you choose not to appear, and just inform the referee, the court ordered that the mother return the child to the father today at 12 noon. Hopefully that's happened. Ms. Johnson, you need to comply with this court's order. It's very critical. So follow this court's order.
Yes,
Make
Your
sure the
Honor,
child
and
to
I
Mr.
think that
Kind
you should
today
comply
at
with
noon
the
at the
safety
Dearborn
of
Heights
the
Police
well-being of the
Department.
child. The best interest of the
And that will
child is that is what you're supposed to be taking into consideration as a judge. That's your job. You're not
back
doing
with
that
an
with my little
attorney.
girl.
Come back to the attorney on
You're
August 21st,
returning
Ms.
her to a
Johnson.
drug-infested
No one has
location
received any
with her
CPS
father,
reports.
as well as sex offenders in the home that live there.
Walker, any questions about the language of the order?
No, Your Honor, I believe I have it.
All right, that will conclude this hearing. You can all zoom out and do comply with this court's order, Ms. Johnson. The court does not want to hold you in contempt of court. And then, of course, that is the consequence if you fail to return that child at noon today.
Your Honor, I would
Okay.
also just indicate to Ms. Johnson that that's inside of the Dearborn Heights Police Department. This way, there's no safety concern to either party inside of the police department.
The
Okay,
safety
understand, Ms.
concerns are
Johnson?
to my child in the home with Mr. Kind and his sex offender son, who is a 13
Right.
year
Ms. Johnson,
registered
Ms. Johnson,
sex
listen.
offender who is
Ms. Johnson,
he's a
Ms.
serial
Johnson,
of
Ms.
children,
Johnson,
Your Honor.
this
That's where
court
you're
has already
sending my little
ordered-
girl.
Okay, mute Ms. Johnson. Ms. Johnson, if you can listen to the court has ordered that there be no other persons living in that home between now and we come back. It would just be your daughter, it'd be Essence and Mr. Kind, that's it.
And just
Okay,
for
that
the
will
record,
conclude this hearing. Mr. Ahmad, we'll see you back on
Mr.
August 21st at
Thank you.
9:45.
Thank you, Your Honor.
I don't know if you got all that, Josh. I know there's a lot of interruptions there.
Your Honor, would you like me to read it to you just to make sure I have it right?
Sure.
Okay. I have that The minor child shall be returned to father at noon today, August 6, 2024. The parenting time exchange today shall be at the Dearborn Heights Police Station at noon.
Put maybe in the police station.
Okay, I can change that to in. Minor child shall remain with father until the next court date. Father shall be the only person living in his home other than the minor child until further order of the court. Mother shall complete a hair follicle drug test and submit the results to the court and plaintiff's attorney prior to the next court date. And this hearing shall be adjourned to August 21, 2024 at 9:45 a.m. for mother to obtain an attorney.
Perfect. And I don't know if you want to send a copy of that to referee Hamrick, who's our conduct the referee hearing tomorrow.
Yeah, I can print a copy out and give that to her.
Yeah, just so she's aware. My guess is she'll put over to August 21st at 9:45, but Miss Johnson wants her hearing on for tomorrow. Okay, perfect. Thank you, Josh.
All right, thank you.
For the record, this matter is before the court for purpose of reviewing custody and parenting time. This hearing is being conducted via Zoom. Present is defendant mother, Shimon Johnson. Also present is attorney Hassad Hamad, representing the plaintiff Edward Kind. Mr. Kind is present with Mr. Hamad. Good morning, everyone.
Good morning, Your Honor.
Good morning.
Parties have conferred with the front of the court. The court has received final recommendation that the child should remain in the exclusive possession of the father until such time as results are received from the mother's hair follicle tests. We thought we'd have that today. Further, it's recommended that mother shall not make any posts regarding this case or Mr. Kind on her social media. And further, it's noted that the plaintiff is requesting mother be sentenced on the contempt finding. That's the recommendation this morning. Miss Johnson, do you understand the recommendation?
Yes, I do, Your Honor.
The status of your hair follicle test. When you were last in court, you advised the court that you had secured that drug testing on August 9th, and you would have the results by today.
I thought that was how it would work too. I did do it August 9th at 10:13 a.m. I have the paperwork. I just do not have the results. They have not dropped into my inbox, unfortunately.
Okay, you need to reach out to that facility. So the court's inclined to adopt this recommendation that the essence stay with that until such time as you have secured those results.
Your Honor, can I ask what facility Miss Johnson had taken her hair follicle test at?
Right, Ms. Johnson, what's the name of the facility?
LabCorp,
Where is that out of?
East Jordan.
What city?
East Jordan, Michigan?
Yes, East Jordan, Michigan.
Okay, so you went in actually to that East Jordan facility?
Yes, I did, Your Honor.
Okay. Well, you got to reach out to them and secure that. I guess probably we should have this review dates. I mean, I don't want this for Ms. Johnson to have to petition the court notice of hearing. It may be difficult for her. So we'll put a review date on this, maybe in 30 days. Mr. Ahmad, how many days was dad denied parenting time? Weeks approximately.
35 days. 35 days.
Okay. All right. So we'll set this for review in about 30 days. Ms. Johnson, if you want to get those results, you can always notice it back on hearing before then.
Your Honor, East Jordan, Michigan that's like almost towards the UP by like Boyne City and Petoskey. Can the court hear me? Sir?
Yes, yeah, I can. And again, I didn't know where East Jordan, Michigan was located, but yeah,
It's
that's
by
Ms.
Charlotte.
Johnson's responsibility. She's got to get those hair follicle test results. So it's on her to produce those.
Well, that just seems odd to me because she was in court in Monroe, and then she was in person the following week. All right, I guess I'm just a little confused because
It's
It's
unusual.
not that far of a drive. I drove there. On the 9th, I wasn't in Monroe on the 9th. I was in Alpena on the 9th. And I do have a son that lives in Lewiston whom I frequently visit.
Okay.
East
Your Honor-
Jordan is the closest place to there. It's 80 miles. Yes, it's a far drive, but I did it.
All right, Your Honor, I would like to address one other thing with the court, if the court allows.
All right, one moment. Are you available, Mr. Hamad, on September 25 for review? September 25 and 10:30?
If I could just check my calendar, Your Honor. Your Honor, I start a mediation at 8:30, and then I have a settlement conference at 12. Can we do the following week?
about October, how about the week before that? I mean, obviously this child should have some contact with mother, and I hate to put this off for 6 weeks. What about do we think September 24th? How about September 24th at 2:00?
I start a trial in Wayne County Circuit Court at 11:30 that day.
Okay. How about then the 18th of, how about September 18th at 9:45?
That works.
All right, Ms. LaPrade, could you put in as a recommendation that the court will review the matter? We'll put it back on our docket September 18th at 9:45, please.
Yes, sir.
All right, Mr. Mod, just one other issue you wanted to address?
Yes, Your Honor. Well, unless the court's adopting the recommendation, then it may address some of the social media posts that Ms. Johnson's been posting about dad being a chomo, which is a childster, as well as just so the court's aware, Mr. Kind gets home and finds a writing on the door, which looks like marker on his front door saying, "You're a chomo, Mr. Kind, you deserve a knife in your chomo liver." I don't know. He doesn't know who wrote that. He doesn't, but obviously it's pertaining to this case because who else is going to do that? And I'm not suggesting we don't have proof that Ms. Johnson did it, but clearly if this is continuously hitting social media and there are her friends or family that are also getting frustrated or whatever the case may be, this might be causing those problems. And based on the contempt, it seems like Ms. Johnson just doesn't know how to stop. So I would ask the court to sentence her or partial sentence, even to pay for attorney fees. She clearly told the court she's looking for attorney. There's no attorney here. It's wasting our time as well as Mr. Kind's time. And that's what I would be asking, but I'll keep it to the court's discretion.
Certainly your position, your statements is unknown, obviously is understood, Mr. Ahmad, and obviously Mr. Kind should contact law enforcement, make a report. And maybe there's some cameras that might pick up whoever did that. And Ms. Johnson, you need to rein in your friends and accomplices. I mean, they should obviously, this is clearly inappropriate. The court will order that you not post anything about Mr. Kind or Essence on social media. This is a matter before this court and you and the father. So you're gonna find yourself and spend some time in jail as a contempt sentence. I'm gonna reserve a sentencing at this time, but you're pushing it, Ms. Johnson, by posting things on social media. That shall immediately stop. And I suggest you bring in your friends, tell them that they're creating problems for you in your relationship with your daughter.
Your Honor, if I may.
Said, I just forewarn you, Ms. Johnson, it's got to stop. And you need to tell your friends that they are creating problems for you and your daughter because this impacts upon you negatively.
Your Honor, and I understand she has the freedom of speech, as Ms. Johnson has stated to Ms. LaPrade, and we understand that. And her freedom of speech under the Constitution is fine. But to talk about what this court's doing, how bad this court's moving forward in this case, how Mr. Kind is a child molester, I just don't believe it's in the best interest of the child. If in the future these two want to co-parent, this needs to stop.
The court would agree. Court fully agrees with your position, Mr. Ahmad, and hopefully Ms. Johnson is listening. So again, this matter is adjourned. Hopefully, Ms. Johnson, you come back with those hair follicle results. If you get them, pass them on to Mr. Ahmad ahead of time. And also the front of the court, right ahead of time. Don't wait till the review date of September 18th to do that. Again, you should not post anything in social media and instruct your friends not to do so about Mr. Kind. They're creating problems for you.
Thank you, Your Honor.
And so we'll adjourn this matter to September 18th at 9:45. Any questions, Ms. Johnson?
No questions, Your Honor.
Okay. All right. Copies will be mailed out. Ms. LaPrade will add that date to the recommendation. Now conclude this hearing. You can all zoom out. Have a good rest of the day.
You too.
Go to Shomo. Go to that Shomo, Lily.
Never heard of it. I just looked her Facebook. Is it open to public or does she just have cover photos?
Yeah, social media creates problems nowadays. And
Oh, it absolutely does.
for the record, this matter is before the court to review defendant mother's parenting time. The court would also note there are pending motions. Both plaintiff and defendant filed motions to modify custody and parenting time. Parties have conferred at length with our Monroe County friend of the court, Ms. Patrick, who has provided the court a fine recommendation that the defendant mother shall have parenting time every Thursday at 5 p.m. until Sunday at 5 p.m. commencing September 19th, 2024. Shall exchange the minor child at the police station in Rockwood, Michigan. The parties shall use AppClose to communicate with each other. regarding the minor child. The parties shall use the friendly court holiday schedule unless they can agree otherwise. And finally, the issue of custody and parenting time shall be referred to the friendly court for formal investigation and recommendation. That is the recommendation this morning. Mr. Ahmad, is this recommendation agree with your client?
So, Your Honor, we have a concern, and I can address it with the court if the court's.
So in answer to the court's question, is this recommendation is not agreeable with your client? Is that the response?
It is agreeable if Miss Johnson lives in Monroe, and we don't believe she lives in Monroe.
Okay. All right. Did you inquire during your conversation with Miss Patrick and Miss Johnson where she resides?
Miss Johnson indicated she lives in Monroe with her father, her maternal father. We believe if you get her father on the phone right now, my client's indicated, he will tell you she does not live with him.
Okay, so you want her parenting time to occur in Monroe County, is that correct?
That's correct, because the 4-hour drive to where we believe she lives is up north.
Okay, well, but she's got to do the driving. I mean, she's got to drive to Rockwood. It's a long drive for a 4-year-old.
That's what I told Mr. Kine. I said she's doing it every weekend if that's the case, and you know.
All right, Ms. Johnson, we'll turn to you. Do you understand the recommendation?
Yes, I do, Your Honor.
Do you have any objection to the court adopting this recommendation?
No, I do not.
Okay, where will you be exercising your parenting time?
In Monroe, and is it okay if we do vacation to Northern Michigan? I have a son who lives there who would love to spend time with his sister.
Well, it's appropriate that you would notify the Apple's dad where you're going. If you're not going to be in Monroe and you're leaving Monroe, your father's home, where do you live? Do you live up north or do you live here in Monroe?
I have a part-time stay, and I do have a residence that I part-time stay at in Alpena, Michigan, as well as Monroe. I stay with my father in Monroe.
Okay. Are you employed?
I'm not employed currently.
Okay.
I'm a full-time student and I'm seeking employment. I'm does not currently employed at the moment.
Do you go to school online?
I do. And
Okay.
I do make extra money through, from not being employed. I make money through Uber and Instacart, DoorDash, stuff like that.
So you have two mailing addresses. You have a mailing address and a residence up north as well as one in Monroe. Is that correct?
That's correct.
Okay.
Your Honor, and sorry but that's the problem. Like Miss Patrick, myself, and both plaintiff and defendant were in the room, right? She never said she had a dual residence, and she was we can't take anything Miss Johnson says with transparency, and that's the concern for us. If you live in Monroe, you live in Monroe. If you don't live in Monroe, say I don't live in Monroe. It's very simple. I mean, this is the issue here.
I do live in Monroe, and it never got to the point in the other room with Miss Patrice. I do not live in Alpena. I visit there frequently because I have a child there. I have family there. I have a whole life that I had there before I had came back down here. So yes, I do visit there.
Your Honor, we believe.
All right. Hang on. It's a long, Mr. Johnson, we're going back and forth. That's a long time to have a 4-year-old in the car. Any human being in a car that long. So the court's going to modify the recommendation. Your parenting time should be alternating weekends. Alternating weekends, Thursday at 5 till Sunday at 5. Alternating weekends, beginning this weekend. Not every weekend. It's a little too much for that child. And Mr. Ahmad, the court is not presented with any evidence that the child's in danger at this house in Alpena. If you think the environment is inappropriate, you can petition the court with some proof that that environment with Alpena is harmful or inappropriate for the child. So the court will grandmother parenting time. Will set it every other weekend, Thursday at 5 till Sunday at 5, meeting at the Rockwood Police Department, and begin this Sunday. So it's a long drive for your child, Ms. Johnson. You got to contemplate where you want to live. There's got to be some stability in this child's life. So driving that far to be alternating weekends. And once we get the recommendation regarding parenting time and child support and custody from the front of the court, Mr. Ahmad, you can renotice that for hearing. Anything further this morning?
Yes, just to let the court know that the minor has been registered in Taylor at Johnson Early Childhood Center, which will start September 30th. And it is Monday through Thursday, which will not conflict with the court's ruling on parenting time.
Okay, and obviously you should provide that information to Ms. Johnson where the child's at school.
We will through the app close, yes.
Okay. All right, Ms. Johnson, any questions?
I'm a little confused on the parenting time. So it's
Alternating
Thursday.
weekends. Alternating weekends, Thursday at 5 until Sunday at 5. You meet at the Rockwood Police Department. And then it'll begin this weekend, September 19th, Thursday of this week. And then alternating weekends thereafter. Not every weekend, but alternating weekends.
It's not every weekend.
It's every other.
Correct. Every other weekend.
Okay.
And the main reason is because of the long drive for that 4-year-old child.
We don't live in Alpena. We have visit there, but we don't have to go there. I mean, it's just, I don't understand why the courts can't go back to week on, week off.
It's a lot for this child. You said you're living at both places. You have no permanent address. You have
I
both places.
personally,
So,
me,
Ms.
not the
Johnson,
child.
The front of the court's going to reach out to you. Hopefully they got your address and they're going to conduct a formal investigation recommendation. Once they've done that, you'll both get a copy of the report writing, and then we can come back and discuss these matters again at that time.
Thank you, Your Honor. Thank you.
All right, if you can modify your recommendation, Ms. Patrick, I would appreciate that. Now we'll conclude this hearing. Everyone can zoom out.
Calling the matter of Matthew Sangaluski versus Savannah Smith.
For the record, this matter is before the court this morning on the plaintiff's motion to modify parenting time. The plaintiff being the father, Matthew Sangaluski. This hearing is being conducted via Zoom. President is Attorney Maria Zagorski, representing the plaintiff father, Matthew Sangaluski, who's present with Ms. Zagorski. In addition, Attorney Lee Rourke is present, representing defendant mother, Savannah Smith. Both parties are present. Good morning, everyone.
Good morning, Your Honor.
The parties have conferred at length this morning with Mr. Pratt, who has provided the court fine recommendation that parenting time be modified for mother. Mother shall have every Monday overnight. In addition, every other weekend, Friday day. So it's presumably Friday afternoon or Friday evening until Monday morning. There's no time set, or the parties can work through that. The exchange will be at the school, and if there's no school, I see it. Exchange will occur at school. If no school, 8 a.m. Father will provide the transportation. Further, both parties shall have 1 week uninterrupted vacation with the minor child. It's noted that father has a minor child hunter beginning August 6, 2024, until Friday afternoon when father returns from Tennessee. Mother will have August 13th, 2024 as a makeup day. That is the recommendation. Ms. Zagorski, is this recommendation good with your client this morning?
It is, Judge.
Thank you. Ms. Worka, is this recommendation good with your client this morning?
It is, Your Honor, but we would request a review date in about 60 days.
Okay, we can do that. Sometime in, what, mid-October?
Yes, Your Honor.
Mr. Pratt, perhaps you can add, if she's still there, she can add a review date.
Yes, sir.
Good morning, Mr. Pratt.
Good morning, Your Honor.
I'm sorry, October 16th at 8:30. Will that work with everyone's schedule?
It does.
I'm available, Your Honor.
All right, we can set a review of parenting time, October 16th, 8:30 a.m. Well, we'll add that to the recommendation. Ms. Zagorski or Mr. Worker, do either of you want to board your respective clients regarding this recommendation this morning?
Yes, Your Honor.
Right.
Thank you.
Ms. Smith, Mr. Sangaluski, will you both raise your right hand to be sworn, please? Thank you. All right, Ms. Worka.
Thank you. Ms. Smith, can you state your name for the record, please?
Savannah Smith.
Okay. And you heard the recommendation that Judge Braunlich read?
Correct.
Okay. And you understand the recommendation?
Yes.
Okay. And you agree to that recommendation?
Yes.
Okay. And do you believe that for right now, that schedule is in Hunter's best interests?
Yes.
Thank you, Your Honor. I have nothing further.
Ms. Zagorski, do you have a question of any questions for Ms. Smith or Mr. Sangaluski?
I do not. Thank you.
All right. Court, I have one question. Is Ms. Smith still have a relationship with this Isaac Bugert?
I'm sorry, Your Honor. What was the question?
Does Ms. Smith have a relationship with this individual by the name of Isaac Bugert?
Yes, Your Honor.
Does he reside in the home?
Yes, Your Honor.
That's a concern of the court. See, Ms. Smith has the males that create a lot of unnecessary anxiety in the home for this minor child. Are they engaged?
Yes.
Yes, Your Honor.
Okay, when's the scheduled wedding date?
We haven't decided because we just want it to be engaged for a little
They're
bit.
just boyfriends and girlfriends right now. Any reason why this court should prohibit Mr. Bugert from being present during mom's parenting time?
Your Honor, my client denies that there was any assault that occurred during that argument.
Well, I don't care. Let's assume there's no assault. It's disruptive conduct for a minor child, a 4-year-old. I mean, it seems like there's more than one. November 20, I'm just going back since the last order of February. I'm sorry, May of 2023. We had an incident in November of 23, law enforcement involved. May of 2024. Okay, maybe the assault conduct, but it's creating not a good environment for this child, for this Matthew Bugert to be around. So the court's question is, does Mr. Bugert I need to be convinced that he should be allowed to be present around this child. Was that discussed at all this morning, Ms. Skorsky, Ms. Werka?
It was not.
No, Your Honor.
All right. Okay. Well, we'll let it go right now, but I'm telling Ms. Smith, if there's one more incident in which there was an incident at home that involves you, Mr. Bugert, Mr. Bugert's not going to be present at all when your child is present. Hunter deserves better than that. So you need to determine who's more important to you, Mr. Bugert or your son Hunter. There's one more incident that there's a law enforcement called to that home. I don't care whether there's an assault, if there's yelling and screaming. You have to choose who you want to live with, Ms. Smith. All right. So the court will adopt the recommendation, and we'll just add the review date. All right. That will conclude here, and everyone can zoom out.
Thank you.
Your Honor.
Record, this matter is before the court for the purpose of reviewing an ex parte order entered by this court suspending plaintiff mother's parenting time. That ex parte order was entered on June 17th, 2024. On account of an alleged assault of the 14-year-old child by the plaintiff mother. This hearing is being conducted via Zoom. Present is Attorney Leah Worker representing defendant father Joshua McDonald. Mr. McDonald is present, and plaintiff mother Blythe Herman is also present. The court notes that actually when our last year was July 2nd, the ex parte order was continued, but mother was granted phone contact with minor child on Sundays, Wednesdays, and Fridays. And I was adjourned to today's date to determine the status of a CPS investigation. The parties have conferred this morning with the assistance of Ms. LaPrade. The recommendation of Ms. LaPrade is as follows. The mother shall have phone calls with minor child Elizabeth on Wednesdays, Fridays, and Sundays at 7 p.m. It's noted that the child is attending counseling. The party shall follow all reasonable recommendations of that counselor. And the minor child shall continue in counseling. It's further recommended that father be permitted to take the child to Florida from August 14th to August 18th. And the parties will appear back for its court to review parenting time September 4th at 9:30 a.m. That is the recommendation, Ms. Worker. Is this recommendation agreeable with your client this morning?
It is, Your Honor.
Ms. Herman, do you understand the recommendation?
I do.
Okay, the court wants nothing more than to reestablish a relationship with you and your daughter. No question, teenagers can be challenging. Do you understand do you have any objection to the court adopting this recommendation?
I would like more availability as far as maybe what the mediator had asked if we could do dinners. I actually reached out to Josh and invited him and his girlfriend to a lunch date with Elizabeth. I'm trying my absolute hardest to co-parent from a distance, and I haven't seen my kid in 11 weeks. I'm heartbroken.
It's not an unreasonable request, Ms. Rourke. What about a daughter having dinner with mom? Dad could drop her off. Mom can, she could suggest a restaurant that maybe that Elizabeth likes. Dad could drop her off for a 1 hour meal with her mom in a public place. Any objection to that prospect?
Yes, Your Honor. At this point, there is. My client, Elizabeth, has started counseling. She's only been able to have one session so far, but she is just establishing a relationship with a counselor. This was a traumatic event. There's no dispute as to whether or not mom slapped Elizabeth. By Elizabeth's account, it was hard enough that she knocked her off the bed. Elizabeth is 14, almost 15 years old. She reported to dad that she liked the counselor and is, eager to continue seeing her. But following this event in May, Ms. Herman attempted to essentially gaslight Elizabeth into, all of the reasons why it happened and trying to minimize it. This was traumatic for Elizabeth, and we think that she would benefit from some additional counseling and the support of her counselor in having conversations with mom to address this rift in their relationship. And we think that Elizabeth needs that support in order to be able to do that in a healthy way. There's a power differential here between a parent and a child. And so
the court understands all that, Ms. Work, understands that. And obviously 14-year-olds can be challenging. I've raised teenagers.
Certainly, Your Honor.
The question is, if Mr. McDonald, if Elizabeth, if mom wanted to meet her for dinner, would Elizabeth refuse to attend?
Yeah, right now, yes.
All right. Well, we don't want to force things, Ms. Herman. If in fact, Elizabeth, we don't want to force things. You should Do you know who the counselor is, Ms. Herman?
Yes.
Talk
I've
with the
actually-
counselor.
Okay.
Talk with the counselor just to get insight in terms of what you can do in terms of reestablish relationship with their daughter. And again, we sometimes you need to, and I don't want to put this off. That's where we're getting review date. The court wants to develop and reestablish and repair this relationship. We've got to do so in a deliberate, careful fashion. And hopefully when we come back, that at least we can maybe have some meals. I mean, talk with the counselor. If she thinks that Elizabeth, now saying what Mr. McDonald said, if she thinks that Elizabeth would be willing to meet you at a restaurant in public for dinner, then there's no reason why we can't talk about that when we come back. But if in fact Dad's saying Elizabeth wouldn't do that, we don't want to force things and create any further problems. What do you think Elizabeth would go? Meet you at a restaurant?
I've asked her a few times and she tells me no every time. So I don't want to push the issue on her,
right,
if that makes sense.
All right, so the court's not going to force it at this time, Ms. Herman. Mr. McDonald, obviously encourage it. I mean, the best thing you do for your daughter is to tell her that her mom, she got one mom in this world, her mom loves her, and that they just need to work out some of their differences. That's all, and encourage that. You have to keep an open mind. All right, anything further than this morning, Ms. Herman?
No, Your Honor.
Okay, we'll review this on September 4th at 9:30. So a month away, and hopefully we can have some personal contact at that time, but do communicate with the counselor.
Yes, Your Honor.
All right, anything further, Ms. Werka?
No, Your Honor. Thank you.
All right, go adopt the recommendation, and we'll review this matter on September 4th, 9:30 via Zoom. All right, that will conclude this hearing. Now we can zoom out. Have a good rest of the day.
Thank you, Your Honor.
Thank you. You too.
Good morning, everyone.
Good morning.
What is the CPS investigation still ongoing, or has that been concluded, Ms. Werka, Ms. Herman?
Your Honor, it has been concluded.
Okay. And closed?
It has been closed, yes.
Any recommendations of CPS? Safety plan or anything?
No. There was admission by Ms. Herman that she had slapped Elizabeth because there were no physical injuries. They closed it with a finding of no preponderance.
Okay. Right, and Elizabeth is still engaged in counseling, is that correct?
Yes, Your Honor.
How often does she attend? Weekly, every other week?
Typically weekly. There have been some scheduling issues. The counselor was out. I believe the counselor canceled an appointment due to being ill. And we did address an issue of a balance owed to the counselor to get Elizabeth rescheduled. We did address that this morning. Ms. Herman had agreed to take care of that balance to get her rescheduled.
Very well. The parties have conferred with Ms. LaPrade from the court this morning, who has provided the court the fine recommendation that mother shall have parenting time on Saturdays from 1 p.m. till 5 p.m. Mother will provide all transportation. The parenting time shall take place in a public place. Mother shall pay $108.47 to Elizabeth's counselor to be able to schedule the next session. And finally, the parties will prepare back for support for review October 23rd, 2024 at 8:30 a.m. That is the recommendation. Ms. Herman, do you understand the recommendation?
Yes, Your Honor.
Are you opposed to the court adopting the recommendation?
No, Your Honor.
How are things going between you and Elizabeth right now?
Phone conversations have been great. We got to see each other on the 30th to do a little shoe shopping, so that was pretty awesome.
Good. And I know last time we talked about you wanted to be able to have dinner with her.
Yes. So looking forward to that.
Okay. Obviously, the counseling is important. So do you agree that you'll pay this sum to the counselor, the 108.47, pay that as soon as possible so we can continue that counseling, which is important in reestablishing the relationship between you and your daughter, Elizabeth?
Yes, Your Honor.
Okay. Are you still, these hours of 1 to 5 doesn't really give much chance for either lunch or dinner. It's like after lunch and before dinner. Are you still desirous of having dinner with her on Saturdays? We extend that to maybe like 6 o'clock.
I would love that.
Right. Obviously, in a restaurant. To Ms. Work, any objection to giving mom more time on Saturdays so she can have a meal with her daughter?
Your Honor, I'll defer to my client. That was the time frame that Ms. Herman requested, and he agreed to that. Josh?
Yeah,
I remember last time Ms. Herman did request the opportunity to have a meal with her daughter.
yeah, that's fine.
Will that give you enough time to have an early dinner then, Ms. Herman, if we change time from 1 to 6?
Yes, Your Honor.
And obviously, there's no reason why you probably know what the restaurants Elizabeth enjoys.
Yeah.
Like give more time to another activity on a Saturday. Right,
Yes.
so we're just if we make one modification, Mr. Pratt, to extend the Saturday parenting time from 1 to 6.
Absolutely, Your Honor.
And with this recommendation, Ms. Herman will be picking up Elizabeth from Dad's house. Is that correct?
Yes, Your Honor.
Right. And obviously, having a 14-year-old daughter, I'm sure she loves to go shopping as well. So if she needs the school closed, it's probably an ideal time to spend enjoyable time with your daughter, Ms. Herman. Just a suggestion. Ms. Werka, this revision, is this acceptable to your client?
It is, Your Honor.
Right. Anything further than this morning, Ms. Werka or Ms. Herman?
No, Your Honor.
Your Honor, I would just note for the record that since we were here in court last, Elizabeth has been going to counseling. My client has encouraged her to communicate with mom. They did go shoe shopping last week. Elizabeth asked if that was something that she could do with mom. That did go well. And so my client is encouraging that relationship. He's hopeful that they will be able to continue to build on that progress with the assistance of the counselor.
Very well. Hopefully with the continued assistance with counseling, we can go back to normal parenting time. All right, so we'll put this back on our docket, October 23rd, 8:30 a.m. Ms. Werka, do you receive regular letters from the counselor updates?
Your Honor, I have not. My client's requested a written update from the counselor. He's not received that from her yet.
Okay. And obviously, there's nothing wrong with Ms. Herman talking with the counselor. Is that correct? She can reach out to her and inquire what she can do to reestablish a relationship with Elizabeth.
That's correct, Your Honor. Elizabeth's appointments historically have been scheduled on Saturday afternoons. That was something that we talked about today. Mom will take her to those appointments so that she can be involved to the extent the therapist deems appropriate with the actual sessions, but also so that she has I guess, easier access or can communicate with the therapist before or after sessions for any recommendations she might have for Ms. Herman directly.
Very well. Thank you, Ms. Werka. Anything else you want to add, Ms. Herman?
No, Your Honor.
Okay, so again, we've changed the parenting time session from 1 to 6 on Saturdays. We'll be back to review parenting time October 23rd, 8:30. Hopefully we can make some real progress between now and then. Right. Everyone will be mailed copies. I will conclude this hearing. You can all zoom out.
Thank you, Your Honor.
Thank you.
Thank you.
You're welcome. Brower.
Good morning, Your Honor.
Again, this hearing has been conducted via Zoom. The court has received the final recommendation from Ms. Brower this morning. Recommendation is that parenting time between mother and daughter will continue as previously ordered, which the court recalls is every Saturday, 1 p.m. to 6 p.m. in a public place. Parenting time will continue if Elizabeth, the minor child, is working on Saturdays or has agreed on a different date to give mother her 5 hours of parenting time per week. The issue of parenting time shall be referred to the front of the court for formal investigation recommendation, with each party having 21 days in which to object to any recommendation, in which case come back before the court. If there is no objection, the recommendation will become part of the court's order. The child, Elizabeth, shall be interviewed as part of the parenting time investigation recommendation. Mother's interview shall be at 9 a.m. Oh, the interviews shall be conducted via Zoom on November 7th, 2024. This order does provide for a Zoom ID number for the front of the court. The person that will conduct the interview. Mother's interview will be at 9 a.m. Father's will be at 2 p.m. My child will be brought to the front of the court in person after school for her in-person interview. All appointments for the minor child shall be added to the app closed calendar at the time they are scheduled by their parent. The parties will return to this court to review all of this on November 20th, 2024 at 9:30 a.m. We will have at that time the front of the court's parenting time recommendation. Ms. Brower, is Ms. Scott still conducting those investigations?
No, Your Honor. Jessica Sisk is our parenting time caseworker, and she will be conducting the interviews and the recommendation.
Working with Ms. Scott?
No, Your Honor. Ms. Scott handles child support.
Okay.
Ms. Sisk is our parenting time caseworker now, and she handles all investigations.
Okay. I know Ms. Scott is getting close to retirement. I didn't know if she was, she's still here, but she's moved from custody parenting time investigations to child support. Is that correct?
Yes, Your Honor.
Okay, I was not aware of that. All right, Ms. Work, is this recommendation good with your client this morning?
It is, Your Honor.
Right, Ms. Herman, do you understand the recommendation?
I do, Your Honor.
Do you have any objection to the court adopting this recommendation?
I'm having a hard time understanding why it's needed, but Elizabeth's not hopefully not going to hold back on some of the things that she wants to talk about with Miss Jessica. Hopefully it's some of the things that she's discussed with me and wanting to get back to normal, the normal 4-3 split.
Okay, well, this is an opportunity. Obviously, Elizabeth is old enough to express her preference and her thoughts and her concerns, and hopefully she will be forthright when she's interviewed. Obviously, neither parent should influence Elizabeth. It will come out in her discussions. All right, it appears appropriate to obviously, if Mr. Obviously, the court's always reluctant to put a child in the middle, but obviously, since the two of you cannot agree, then it's unfortunate, Elizabeth. I'm sure the last thing she wants to do is be interviewed by some court representative. But since your parents cannot agree, then that will happen. If you can reach an agreement between now and that November, we can always call off that interview. Obviously, Ms. Herman, you're wondering why it can't be done. Well, obviously, Mr. McDonald will not agree to any expansion of parenting time. And that's something you can discuss with him in terms of his reasons why.
Over our messages on the app close, it was to my understanding that Josh was eager to get things back to normal. But here we are.
Your Honor, I believe that's a mischaracterization of Mr. McDonald's messages. Elizabeth is almost 15 years old. We're in this position because of Ms. Herman's actions. My client is encouraging Elizabeth to spend time with her mother. He has been accommodating to, adjust schedules and times for visits, and he is committed to continuing that. But Elizabeth is almost 15, and as a teenage girl, she has opinions that she has expressed to her father. According to Ms. Herman, she's telling her something different, and we believe that it's important for her to have the opportunity to speak with Ms. Sisk or a friend of the court in order to make a recommendation for parents.
Is Elizabeth still engaged in counseling?
Yes.
She is.
Okay. Ms. Herman obviously should talk with the Elizabeth's counselor to see what you can do constructively as a parent to repair that relationship and rebuild that.
Your Honor, I've been to 3 of the counseling sessions, and I have spoken with her as well.
All right. That should give you some insight in terms of where Elizabeth is.
Yes, Your Honor.
But no question, obviously, every young woman needs a active mother in her life. It's critical. So, Mr. Herman, whatever you do to facilitate that, encourage that, please continue to do so. In any event, the court will adopt the recommendation. You both know the copy. Please note in your calendars the Zoom interviews with the front of the court on November 7th. Presumably, Dad will bring in Elizabeth to the front of the court after school on that date. Is that correct?
That's correct.
All right. Okay, then we'll see everyone back here then to review parenting time on November 20th. That's a Wednesday at 9:30. All right, that will conclude this hearing. Everyone can zoom out, and that will have a good rest of the afternoon.
Thank you, Your Honor.
All right, thank you.
Good morning.
Good morning, Your Honor.
Parties have confirmed with Ms. Patrick this morning, who has provided the court with the following recommendation: that mother's parenting time shall be every first, second, and third weekend of the month from Friday after school or 4 p.m. if no school until Monday back to school Monday morning or 9 a.m. if no school. The parties shall use the front of the court holiday schedule unless they agree otherwise relative to holidays. The parties will each have 1 week, uninterrupted summer parenting time with the dates to be agreed upon by June 1st of each year. Further, that all parenting time complaints will be considered to have been dealt with as if the state as both parties have violated prior court orders. So that we'll start with a clean slate hereafter. Ms. Herman, do you understand the recommendation?
I do understand. However, I would like to have that fourth weekend as well. And because I haven't had any time at all this summer or up until this moment.
Well, obviously there's some issues between you and Elizabeth that prompted that breakdown for a period of time. But again, obviously dad should have some weekend time too. I mean, your daughter's busy with school, dad's working, so they should have some one-to-one time. So of course not going to give one parent every weekend of every month. Now, I guess we can talk about if there's a fifth weekend. If there's some months that have a fifth weekend. So we'll discuss that in just a minute. Ms. Burke, is this recommendation good with your client, Mr. McDonald?
It is, Your Honor.
Any objection to if there's a fifth weekend that mother would have the fifth weekend?
Your Honor, I believe that there would be. Our initial request this morning was that the schedule be every other weekend rather than the first three. Just there are some concerns lingering. My client is trying to be reasonable and has agreed to the 3 out of the 4 weekends. So we would request that the court follow the recommendation at this time.
Well, of course, the front of the court did conduct a formal investigation, which I believe included an interview of the child. And this recommendation appears to be consistent with that recommendation. Unless you want to make the mother has the first, second, fourth weekend, would that make a difference for dad?
I mean, I would just rather keep it how what we agreed on.
I don't believe that the which of the weekends is dad's is necessarily the a deciding factor for Mr. McDonald, Your Honor. But he's requesting that the 3 weekends be given to mom, that be the order of the court.
Very well, the front of the court has investigated this matter and reviewed the minor child. And this recommendation appears to be consistent with the front of the court recommendation to this court. We'll rely upon the recommendation in front of the court and is inclined to adopt this recommendation.
Your Honor, can I get some clarification for the summer? Would I still be first, second, third weekend?
Correct. And if there's no school, then of course you'd your parenting time would be Friday at 4 o'clock and then 9 o'clock back to 9 o'clock on Monday morning. If there's no school, and that'd be in the summertime. If there's any issues, you can petition the court. Anything further this morning, Ms. Burka?
No, Your Honor, I don't believe so.
Okay. All right, teenagers are challenging, Ms. Herman, Mr. McDonald, and obviously it's important that Elizabeth have a relationship with her mom. So obviously you need to be aware and sensitive to the needs of a teenager, Ms. Herman. And Ms. McDonald, you need to obviously encourage that relationship between your daughter and her mother. She only has one mother and one father in this world. So it's important that both of you foster a good relationship between your daughter and the other parent. For example, making sure little things are big things, making sure that your daughter gets a Christmas gift for the other parent. Mom, you should encourage her to get something for Ms. McDonald. Ms. McDonald, likewise, make sure that Elizabeth gets something for her mom. Just those simple acts mean a lot to Elizabeth, that each of you respect the other. All right, with that, and of course, that will start presumably this weekend. And the two of you have to talk about Thanksgiving. You can both go online and get the Monroe County Front of the Court holiday schedule. Obviously, if you cannot agree upon Thanksgiving holiday, then the Front of the Court schedule will control. And mom's parenting time will start this weekend. So Friday after school. So dad, let her know that the mom's gonna pick her up after school on Friday.
Your Honor, I believe this would be the 4th weekend of the month.
Oh, I'm sorry. I'm looking at this month of December. I'm sorry. That's correct. This would be the 4th
any
weekend.
harm in it starting this weekend?
I will leave that between you and Mr. McDonald.
Say that again.
Ms. Sherman is asking if she could have this coming weekend.
No, this weekend I already had plans set up. I mean, she did have her this weekend for her parenting time.
So does my parenting time for my 5 hours doesn't go towards this weekend? Per the
sorry,
last
wait.
order?
Well, it's a good point. The prior order gave you a parenting time Saturdays from 1 to 6. So what plan do you have, Mr. Mick? Now, why shouldn't she have this Saturday from 1 to 6? And this new schedule could start in December. That's a good point.
Well, I always do. This weekend would be what, Thanksgiving?
No.
Next.
No, the following week.
The following week? I mean, I would at least like to have a weekend where I can spend time with her.
Well, you spent the last 2 weekends with her. I mean, all right, the court's going to order that the mother shall, for any time we can clarify this, that this schedule, the mother's first, second, third weekend will commence with the month of December, and mother will have parenting time this Saturday from 1 to 6 for the last order of this court.
And then as for Thanksgiving, which is the following weekend, we'll base it off of the court's recommendation online.
Yeah.
Yes, yeah, Saturday the 30th. So you should have her, Elizabeth, on the next 2 Saturdays of this month, 1 to 6. And this recommendation of first, second, third weekends, that will start with the month of December. But the remaining 2 Saturdays of this month, mom will have the parenting time Saturdays 1 to 6.
Your Honor, the last Saturday of this month would be the 30th, which would be covered under the Thanksgiving holiday at the front of the court holiday schedule.
Okay, and who has Thanksgiving this year?
That would be Dad.
Right. I'm going to talk with Ms. Patrick about the Thanksgiving. So clarify that some of these points are all valid points. I don't know when Ms. Herman celebrates Thanksgiving. If she wants some part of that weekend, it would be reasonable. So Ms. Patrick, we can just talk to them another 5 minutes to see if they can want to clarify the courts. We'll order this first, second, third weekend commence with the month of December. And then mother out parenting time in the interim Saturdays 1 to 6. Just a question of whether or not what we're going to do with November 30th, which is part of the Thanksgiving holiday. So if you can see if the parties can find some middle ground with respect to that, we'll put you back in the breakout room.
Okay. Thank you.
For the record, the parties have conferred with Ms. Patrick further this morning regarding parenting time for the plaintiff mother. Ms. Herman, Mr. Werka, thank you, Ms. Patrick, for discussing the issue further with the parties. The court's received a revised recommendation. Again, that mother will have the parenting time the first, second, third weekend of each month. This begin with the month of December 2024. Her parenting time will be on those weekends, Friday after school or 4 p.m. if no school, until Monday back to school or 9 a.m. if no school. In the interim, plaintiff mother will have parenting time November 22nd. So rather than after school, it'll be 4 o'clock.
Okay.
I know she gets off the bus at like 3:30, so I'd be showing up right around that time so she can get situated and everything.
All right, so the pickup and drop offs will occur at Dad's house. What about Monday? Are you take her to Dad's house to get the bus, or you take her right to school?
I would be taking her right to school. Granted that she still has all of her belongings. I will make sure that she's aware that she'll be going right to school.
Okay, and so make that known to Elizabeth, Dad. And obviously, if there's any changes, we need to communicate about that.
Yes, sir.
Yes.
All right. Court will adopt the recommendation. Thank you, Ms. Werker, for your continued assistance this morning. Thank you, Ms. Patrick. The court applies to we've reached your own agreement, so let's hopefully this will work, and mother can restore a relationship with her daughter. All right. If there's nothing further that could conclude this matter, you can I want to zoom out. Have the rest of the morning.
Thank you, Honor.
Thank you. You too.
And for the record, Mr. Bracey has been brought before this court at the request of Monroe County Front of the Court to Attorney Rebecca Hicks, and both parties are present via Zoom. Obviously, Mr. Bracey, the court can only assume that you're brought before this court because you're not complying with past orders of this court regarding child support.
Yes, sir. I'm late this month.
Okay, Ms. Six, can you provide the court some information regarding Mr. Bracey and this case involving Ms. Cunningham?
Certainly, Your Honor. This case was adjourned to today's date from a hearing that was held on July 2nd. At that time, the order was entered that he would ensure that his July support was paid by end of business on July 31st of 2024, or a bench warrant could issue. This case has a current monthly support obligation of $329 per month. Of that $329, Mr. Bracey paid $40 yesterday. The current arrears on this case are $8,412.32. There is a previous finding of contempt. It's from March 5th of 2019. That was a first finding, and he has fully served that sentence.
So obviously, you expect Mr. Bracey would pay that difference today. Should have paid that last week, correct?
Correct, Your
Yes,
Honor.
sir.
And this is just trying to limp him along at current support without even asking anything towards that over $8,000 of arrears.
All right, Mr. Bracy, can you pay off that $300 balance today?
I can have it. I can have it by Friday, Your Honor.
Well, today's Tuesday. Then,
Yeah.
Then what about the August child support? You can pay that
I
as
would
well
try
on
to have-
Friday?
I can't pay that. I can try to have it by the next week.
Are you working
Yes, sir.
full time?
Yes, sir. Well, weather pending.
Okay, so you need to come to the front of the court. It's a 4-page list of employers that are screening for employees. You can't work a job that's weather dependent, Mr. Bracy. You need a regular, consistent income. You got $8,000 in arrears.
Yes, sir.
Over 8,000 arrears. So, Mr. Bracy, you're if you don't take care of yourself, you're looking at some jail time.
Yes, sir. I understand.
Well, the court expects you to pay more than $300 on Friday. If the court's going to give it till Friday, you need to pay more than $300. You get paid on Friday?
Yes.
How much will your paycheck be?
Well, considering today's about a half day, I would say around $500.
Okay. Can you pay $500 on Friday?
I can do my best, Your Honor.
Well, it's
I mean,
not good enough, sir.
that'll leave me with
Nope.
absolutely
It's not
nothing.
good enough, right, Ms.
Yeah.
Hicks? It's not good enough, Mr. Bracy. That well, I'll try. Either you
Then
can or you
then
can't.
yes, Your Honor, I will pay the full 500 on Friday.
Ms. Hicks, in light of that, so what's your recommendation?
Your Honor, then if we could adjourn this matter to Friday, to ensure that he makes that payment.
This court will be out of the jurisdiction on Friday, so we can do it on
that's
Monday
right.
if you want.
Yes, can we do Monday, Your Honor? Oh, wait, you are talking.
Yes. The court's out of jurisdiction Friday, and then Monday and Tuesday of next week. I'll be back on Wednesday.
Can we come back on Wednesday next week then? Is that the 14th?
Okay, yes. Do you want Mr. Bracy to appear in person?
Yes, Your Honor.
All right, Mr. Bracy, the court's going to order you that you appear in person, actually a week from, we're going to give you a week from tomorrow. That's August 14th, 11:15 a.m. in the 4th floor, Bronx Court.
Yes, sir.
And the court will expect that you'll pay minimum $500 on or before that date.
Yes, sir.
So if in fact you're going to spend it, you better pay it on Friday, because obviously if not, the court will commence contempt proceedings. So you pay minimum $500 and appear personally on Wednesday, August 14th. And you got to pay that in cash. You can't pay it online. You got to pay it in cash.
Yes, sir.
Now, if Mr. Bracy pays the $500 cash fee now and then, do you have any objection to him appearing by Zoom?
I would not have an objection to him appearing by Zoom if he's paid $500 prior to then.
In cash rather than online.
Correct. If he makes an online payment, I'm going to require that he be here in person.
All right. So, Mr. Bracy, if you pay the $500 cash, you can appear by Zoom next Wednesday, week from tomorrow.
Yes, sir. Because
you got to pay in cash. If you pay online, you can then cancel that. So that's why we want you to come in to actually pay cash in front of the court, $500 minimum. Again, it's all going to apply toward your arrearages. You really keep on top of your arrearages. So $500 minimum on and before August 14th. It's got to be cash. And if you have paid that before Wednesday, if you paid on Friday, that's of course just paid on Friday, so you can appear by Zoom next Wednesday.
Yes, sir.
And of course, Bronx Court is on the 4th floor. Any questions?
No, sir.
Okay, so that should be your goal, to pay the $500 on Friday so that you can appear by Zoom next week and you don't need to interrupt your work schedule. Take 5 minutes on Zoom.
Okay.
Anything further than this morning, Ms. X?
Nothing on this matter, Your Honor.
Okay, Mr. Bracy, any questions?
No, sir.
Okay, all right. You can zoom out. Have the rest of the day. Bracy, good morning. For the record, Mr. Bracy is appearing in person as directed this morning. He has provided the court a receipt showing he paid $500 this morning in cash towards the arrearages of over $8,000. Also present is Monroe County Friend of the Court Attorney Rebecca Hicks. Ms. Hicks, good morning. Are you aware that Mr. Bracy paid $500 this morning?
Yes, Your Honor. I can see that in the system.
Okay. And Mr. Bracy, if necessary, file a motion to reduce your support. You gotta be proactive in this obligation. Otherwise, right now it's probably, I think, $329 a month. If you can't afford that, you need to file a motion to reduce support. Just don't sit in your hands. Did you pick up the packet of the forms to file your motion?
I've already got.
Okay.
That's where they
Okay. Do you have a hearing date? Do you have a hearing date? Okay. I'm not sure that Ms. Six, I'm not sure what Mr. Racy's talking about. He currently filed a motion to reduce support.
He did, and he failed to appear, so his motion was denied. He has to file a new motion because he waited until the objection period has passed, so he can't object to the denial.
You got to file a new motion, Mr. Bracy. Make sure they have your correct mailing address. I mean, obviously, I don't know why you didn't appear on your own motion. Okay, well, you look at I'm sure in front of the court, do you know who your caseworker is? Talk to your caseworker. They can show you all the paperwork. You're able to notice he didn't appear. So you got to file a new motion. There is no motion pending. Do that today before you leave. All right, so Ms. Hicks, and hopefully Mr. Bracy will be proactive and then file another motion today to reduce his support. It's clipping along at $329 a month. What's your recommendation now that he's at least been made a payment of $500?
Your Honor, based on the previous order and why we brought him to you, that $500 payment is meant to basically be his July payment, and I guess maybe part of his August payment. So the friend of the court is willing to do a very short adjournment to monitor that he continues to make consistent payments until or unless this court order changes. We're going to be looking to receive a minimum of $329 every month, as well as something towards those arrears since they are over $8,000.
So you got to pay more than $329 a month, right? So what are you suggesting, Ms. Six, for the adjourned date?
September 10th at 8 a.m., Your Honor.
And that'll be on your docket, is that correct?
Correct.
Okay. And I'm sure this $500, that is considered the July child support?
Yes, that is correct, Your Honor.
So, right, Mr. Bracy, since you made the payment, the court will continue this matter. We're not going to start any contempt this morning, but you're to appear before Ms. 6, September 10th at 8 a.m. And you need to pay the $329 plus between now and then. I mean, you haven't paid anything for August. This July, or July. Well, someone's going to, I mean, you got 8,000 arrearages. So yes, the court's going to expect, I mean, when I'm looking at you, they should maybe, when you come back September 9th, I mean, you should have paid another $500 between now and then. That's what the court's suggesting. If not, you're going to be back with Ms. 6 going to bring you back for this court, and let's not go there. So, I mean, at least if you make $500, that's covering your August payment and maybe some towards your September payment. But you got to really start chipping away these arrearages. And if you can't afford it, file the motion to reduce support and appear for the hearing. We can Zoom. You can appear by Zoom. You step out, just take a break, and you need 5 minutes to appear by Zoom. You don't need to take off work and drive here to Monroe. Ms. Hicks, is he required to personally appear? If he files a motion to reduce support, does he have to personally appear?
No, he will receive Zoom instructions and can appear via Zoom with referee McKee for that hearing. He was mailed Zoom instructions for the last one.
When you file the motion asking, yes. Okay, they gave you Zoom instructions. So when you appear on September 10th, you can appear via Zoom with Ms. Hicks. Okay, file your motion and then tell the referee that you want a Zoom hearing. We're trying to make things easier for people. We don't want to pull people off their work. All right, do you have any questions, Mr. Bracy? So September 10th, 8 o'clock, go down and talk to your caseworker, get another support packet, and make sure we have your correct mailing address. For the record, this matters before the court, and the defendant files a motion to enroll the minor child in school. This hearing is being conducted via Zoom. President's attorney Jason Kazmarek, representing the defendant petitioner, Douglas Klatt. Mr. Klatt appears to be present. And it looks like we have someone upside down here or sideways. You're Kristen Westfall, is that correct? There you go. That's much easier to see you.
Sorry.
Right. All right, the court's been informed, Ms. Westfall, that you want to retain an attorney. Is that correct?
Yes.
Obviously, the timing is very critical. We need to make a decision on the enrollment of this child in school. Mr. Klatt is requesting Monroe Public Schools, and you're opposed to that?
I am aware that we're in like a time sensitive nature on this. I was not aware that there was an issue with schooling up until I got the papers in the mail. I have verbal consent from Mr. Collette to homeschool this year, so I don't even know how we got here.
Mr. Kazmarek, has the minor child been enrolled in Monroe Public Schools?
He has, and again, I know that Mom was kind of upset, I think, about an IEP that the school did, saying that he no longer needed the program.
The court's aware, the court's read all the
Understand.
pleadings, the court's all aware of all that.
So,
And I'm just
but as far
asking
as
if he's been
the child
enrolled.
the child has been enrolled at Manor
Okay.
previously, but my client is fine with some kind of faith-based program as well, like St. Mary's or St. John's, and potentially willing to fund most of that as well. So
He just wants them in person in school as opposed to homeschooled, is that correct?
yes.
Right, and Ms. Westfall, you're opposed to DJ going in person to school?
Correct, and DJ does not want to be in school either, and he has voiced these concerns to Mr. Klatt as well. I have text messages just so far as the beginning of July where Mr. Klatt has agreed for him to be homeschooled and to purchase his books this year. So I don't know where we're at with public school and how we got here when just a few weeks ago he told me he purchased books and he was fine with DJ being homeschooled.
I think my client disagrees with that. My client's always willing to support his child. I mean, whatever he needs. I don't think he's ever consented to the child being in homeschool. That's the biggest problem. I know that mom kind of did that with the understanding that a misconception of how he's going to be taught. But I know this homeschooling program is supposed to start on the 19th. There's no teachers. Miss Westfall is the teacher. Her boyfriend is the principal. And if this was a true, more online school, there's online teachers or something, my client could be more open to it. I know that he's concerned about the interaction with other students and teachers and having programs available for this child. And he's not getting that. And that's what he's most concerned about. Whether, again, he's willing to foot the bill for most of this stuff. It's so he's not getting updates for his education. He wants somebody accountable, giving attendance records and grades. Miss Westfall does all the grading, and there's no information to Mr. Klatt about how this child's even doing. It's just
that's false.
He wants the child.
It sounds like Mr. Klatt and Miss Westfall need to communicate and talk about what's best for their child. Have they talked about this?
Mr. Klatt refuses to communicate with me.
Oh, he would love to.
I have sent numerous
All
text
right, so
messages.
hold on. Right, again, you need to get an attorney on board real quick, Miss Westfall. The child's been enrolled in Manor schools, and that will start the first week of September. Is that correct, Mr. Kazmarek?
Well, he had been previously enrolled in Manor, so mom unenrolled him and did a homeschooling program, which is set to start the 19th.
He can be enrolled. He can be enrolled in Manor school. That doesn't start till the first week of September. Is that correct?
Yes.
We have already agreed for him to be homeschooled this year, and I have already spent close to $600 for him to be homeschooled this year.
We have to reimburse you for that. If in fact, Ms. Westfall, get some receipts together. If in fact you purchase those supplies based upon representation agreement with Mr. Klatt to homeschool and you incurred that, no reason why you can't tutor your child in addition to the regular schooling. But there is some value in in-person school, socialization with other students, extracurriculars. So the court will allow them to be enrolled in Manor Public Schools and start there the first week of September. And if you want to, can you get an attorney here before then?
My attorney is asking to adjourn this for 2 to 3 weeks so he can file.
He's not here. If I set a date, he's gonna say, well, that date's not agree with me. So I can't guess about a date, Ms. Westfall. So here's what I'm gonna do. The court's gonna, is Mr. Klatt opposed to reimbursing Ms. Westfall $600 for the education materials?
No, not at all.
All right, so provide a receipt for the education materials, Ms. Westfall to Mr. Klatt, and he's ordered to reimburse you for the education materials that you've incurred so far. The court will also order and allow this child, because we're on the eve of we're less than a month before school begins. The child can be enrolled in Monroe Public Schools, Manor schools. If in fact you disagree with this strongly, have an attorney file a motion to ask court to reconsider, Ms. Westfall. There's no reason why you can't do both. Can't you tutor him and help along and he'll be a super student?
I'm sorry, please give me a second to collect myself. It's not tutoring him. I have a whole school curriculum through a accredited homeschool facility with actual subjects laid out with actual lesson plans for each individual day. I follow a whole lesson plan for each day for each subject. It's not just me tutoring him or making up my own curriculum. It is a whole curriculum based off of accredited college out of Florida, where each subject is laid out day by day with homeschooled lesson plans that he would follow just like as if he was in public schools. The only difference is he's not being bullied. He's not being made fun of because of his autism. He's not struggling to make friends and be bullied by said friends because he acts differently or has to learn in a certain manner. I don't understand how
but
he
you're
can
not a certified teacher, correct?
I'm sorry.
You're not a certified teacher.
I'm not a certified teacher, but I have taken plenty of online courses on how to deal with my autistic son.
Okay. And Mr. Kaczmarek, Mr. Klatt disputes this finding of autism. Is that correct?
I don't, it just, I've never been involved in any of this diagnosis of my son being on the spectrum of autism. And he was at the Arborwood School for Autistic Children. They put him into Manor because he no longer needed the teaching that it was taught in the beginning about the autism. Had he had autism, I'm assuming they would have kept him there instead of sending him to public school where he succeeded. And I have the records, the documentation from the school board. There was no reports of bullying. He succeeded the level to need an IEP teacher, and his grades were fine. He was being successful the whole year that he was in Manor. He did great, and he was able to function, get along with the children. And there was reports of bullying and stuff. I went to the school board. There was no files of any bullying. There was no reports of struggling with grades. He was doing fine with his report cards, and they took the IEP because he was above the level to require it, sir.
Right. Well, Mr. Klatt, you should be involved. And on top of all those evaluations, when you say you weren't really involved in them, you should be. The two of you are parents. You should know what's best for DJ, and you're making a total stranger decide what's best for your child and raise your child, which is very unfortunate. You need to get on board, Mr. Klatt, and communicate with mom and Mr. Westfall too. We need to talk. You should both be involved in a mediation session so you can work through this together. There'll be future issues if you cannot agree upon school. This is the beginning of many issues. So at this point in time, Mr. Klatt, you order to reimburse Ms. Westfall any material costs that she has incurred, and the court will permit the child to be enrolled in Monroe Public Schools, Manor School. Ms. Westfall, if you disagree with it, you want to have an attorney file a motion. And again, there's no harm in DJ starting a week or two of school if we need to change horses. But the two of you should talk, and maybe Mr. Kaczmarek and Mr. Vidal files in Paris. Maybe you can schedule a mediation between with the front of the court. I'm sure the front of the court will be willing to mediate with the parents to talk through this together.
This is so unfair to DJ to be forced into school for a few weeks to be pulled out when Mr. Klatt has already. I have text messages from this year that he could be homeschooled. So why are we even going through this process?
I can't answer that question, Ms. Westfall. Mr. Klatt he owes you that explanation, but in the meantime, he's going to reimburse you 100% of whatever you've incurred for educational materials. So, Mr. Klatt, you need to talk with the mother of your child. Otherwise, you're going to have problems with DJ. I'm telling you. So if you can prepare an order to that effect, Mr. Walker, this does not prejudice to Ms. Westfall. She can still have an attorney file a motion to reconsider the issue. But out of times of the essence, we can't wait. We need to make some decisions. And Mr. Klatt, if he's being bullied, you should be cognizant of that. Maybe it's best that you homeschool if he's being bullied and he's got autism. You should contact the people who did some of those reports.
I did.
The IEP says he has really good social skills and they get along well with other students. That's why he's confused with that assessment from mom.
That's because Mr. Klatt doesn't reach out to me. He does his own investigation and then just goes from there. He's yet to reach out to me about anything.
I'm the one that asked you about the bullying and the homeschooling.
Okay. All right, Mr. Walker, if you can prepare an order in accordance with the court's instructions, and that will conclude this hearing. Ms. Westfall, you get contact Mr. Vidal and have him file a petition with the court. All right. That will conclude this matter.